Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. We have a town crier. You may all be seated. I love it. Thank you, everyone, for being with us today. We have 3 cases before the court. The first case is Shantz versus Mercy Medical Center, and it will be submitted without oral argument. Our first oral argument today is State versus Thompson, and it looks like the parties are ready. Ms. Wilson, you may begin.
May it please the court. I'm here today representing defendant appellant Brian Thompson, who is convicted of 2 counts of theft in the 2nd degree as an habitual offender. There are 2 questions presented in this appeal. First, the district court err in omitting an element of causation from the marshalling instructions for theft by deception. Second, does harmless error apply when an essential element is omitted, or does structural error apply? The state's theory in this case was that Mr. Thompson obtained Ms. Wall's money by misleading her to believe he was a bondsman with Custom Solutions Investigations. The Iowa Code, case law, and model instructions recognize a causal connection between the deception and obtaining the transfer of property of another. Iowa Code 714.13 says a person commits theft from a person when they obtain a transfer, possession, control, or ownership of property of another by deception. State versus Ross and State versus Fiedler are both theft by deception cases, and they acknowledge that this statute is based on the Model Penal Code. The Model Penal Code comments say that it sufficed that deception was effective in securing the property. Again, a causal connection. This is also reflected in Uniform Criminal Jury Instruction 1400.10, which includes a reference to obtaining the property by deception in paragraph 3. When the district court in this case instructed the jury in instructions 14 and 15, it left out the phrase by deception. Instead, the instructions provided the defendant did obtain the transfer of possession, control, or ownership of the property from Mary Wall, and the defendant knowingly acted with deception. The court specifically rejected the model jury instructions, finding it confusing. The defendant did request the equivalent of the model jury instructions. He specifically requested that the phrase by deception be included in the same line within obtaining the property. This request, as well as other irrelevant requests to this appeal, was rejected by the district court. He reiterated these requests as grounds for a motion for new trial, and again, it was rejected. The court's marshalling instructions, therefore, were not a correct statement of law. Now, the important question.
Causation piece wasn't explicit, but I mean, it seems implicit in the instruction that because it's a theft charge and there's a date identified, that the deception relates to the taking. Maybe it's not the best instruction in the world. I think everybody would agree with that. But the jury knows why they're there, and I think it's hard-pressed to believe that they think the deception would have nothing to do with the taking of the property. So isn't that causation implicit?
Their juries know what the instructions say. They are told to follow the instructions. The instructions omitted the causation element. We should not assume that the jury understood that causation was implied.
Would it have been a less concerning instruction if number 2, because number 1 says on a certain date, they did obtain, or the defendant obtained property. What if number 2 said the defendant knowingly acted with deception at that time? Would that have made a difference?
It would have been better, but I, again, don't think it really establishes the causation. It has to be by deception. And if you look at the facts of the case, there are reasons to believe that it wasn't originated through deception. I'll start off with how Mary Wall contacted Brian Thompson. She Googled him. His was the first, well, she Googled for a bondsman near me, essentially. And his was the first name that showed up, and it was associated with the website for CSI. So she calls CSI.
The record. Googled, and his personal name came up first, and she called whatever the number was and asked for him.
Right, and then she talked to Mr. Gilbert at CSI, and I believe she does testify that he told her he did work there, and then provided the contact information for...
And then he gave her paperwork that showed, that was forged paperwork showing he did work at CSI, and then he gave her, additional forged paperwork that said that he was, that this insurance company was going to be providing a cash bond, and the jury heard that that's impossible. Insurance companies don't even provide cash bonds. And she gave all of her money, to him, whatever, the $6,000, the two installments of $3,000, based on those representations. She wouldn't have given $6,000 to a person in the street, right? She wanted a bail bondsman, which he wasn't.
He was. If you look at Exhibit 16, there is a license for him as a bondsman. The question that was presented on, well...
I bail bondsman, he didn't, and he was providing something that couldn't have been a bond.
...a bond. As a bondsman, he can provide cash or surety bonds.
In other words, he would have to put up $25,000 in cash in order, is what the jury heard, in order for there to be a cash bond. The arrangement he showed to her was not an arrangement that anybody was going to put up $25,000 in cash.
Do require the full amount of cash. But if you also look at Kenny Nolf's testimony, who again is a licensed bondsman, he provides cash bonds. He doesn't put the money up himself necessarily. He gets collateral agreements from his clients, and there were collateral agreements in this case for this bond. But as far as her testimony, I believe on page 80 of the transcript, she testifies that she put Brian Thompson in her contacts because she believed that he was a bail bondsman and could post the bond. He was a bail bondsman. It was irrelevant as to whether or not he was associated with CSI. She wanted someone who would be able to post the bond, and Mr. Thompson was authorized to post bonds.
But he wasn't able to do so. The jury heard that. He wasn't able to do so. The method he was proposing was this agreement with an insurance company that insurance companies, the jury heard, don't do that. They aren't in that business.
That is an accurate statement of the record. Unfortunately, we don't have Mr. Thompson's testimony to be able to explain that. So let me just say, based on...
It was his choice.
So let me just say, based on the record before this court, we are not challenging sufficiency of the evidence on deception. I do believe there is evidence from the testimony presented that would question whether there was, in fact, a deception.
Because I'll agree with you that I think that, I'm kind of surprised the court didn't just say, fine, we'll just use the uniform instruction or put your word by in there. It seems like a pretty minor thing to make the defendant happy. So I'll give you that. I'm having a heck of a time understanding the diff. Tell me, how could anyone look at your set of facts any other way than it was taken by deception? I don't get it. It's not hypotheticals. With these facts, how could it be anything but that? And I know we're leading into the, okay, then is it harmless or not?
Again, she was looking for Mr. Thompson as a bondsman. And the causation really goes to whether or not she would have rejected Mr. Thompson had she learned up front whether or that he had not worked directly with CSI. But he was a licensed bondsman, and their relationship was a bit complicated. There was multiple text messages back and forth, sometimes on a daily basis. And to the point, and even she admits, that Mr. Thompson offered to give her money back, and she declined. She admitted it may have been more than once, but she declined.
Me, when people feel like they're in trouble, they try to get out of it, but that doesn't escape the fact that he got the money to begin with. So what are you saying perhaps maybe she would have chosen this guy even without all of those fake credentials?
Yes, she.
Back, he in the middle of the transaction, she there's some delays, and he offers her money back, and she says no. But then when she actually investigates and finds out, oh, he didn't work for CSI, and she asks for the money back, there's no money coming back, right? Once he's found out, there's no offer of a refund.
Reflection of the record, except keep in mind that his duty to perform was to post the bond theoretically on May 15th. The dates kind of fluctuated. It may be a day or two later, up until potentially May 20th or 26th. But he was ideally supposed to post the bond on May 15th. At 1:15 on May 15th, she has contacted the police. At that point, he is not able to fulfill his end of the bargain. She has basically breached the contract.
She's breached the contract because she went to the police, because she found out that he didn't work for CSI, and all this paperwork he'd been giving her was a fake?
Paperwork was not a fake, Your Honor. The collateral agreements were legitimate.
Agreements where she posted her car as collateral, that might have been legitimate, but the agreements that were supposed to result in the delivery of the bond were fake, right?
Were, again, based on the record that we have, I'm not going to argue the deception. But suffice it to say, going to the police cut off his ability to perform on May 15th as they had agreed.
Curtail further criminal activity.
Can we go to the harmless error question? I read the 1983 Seiler case as answering this question. It hasn't been overruled that I've seen. How do you get around that case?
Recognized in Coleman and Schuler that our case law has kind of been all over the place when it comes to harmless error versus structural error. There are cases like Seiler that have used harmless error, and that includes Schuler, where the issue was not raised in the appeal initially. It includes Coleman, where the parties didn't argue which standard applied. But then there are cases that have used structural error or its equivalent.
There are cases where, there are 3 cases you cite in your brief where there were reversals for problems with the jury instructions, but there wasn't a harmless error argument raised. So I don't think that's dispositive. The last case that really squarely confronted the issue was Seiler, wasn't it?
Yes, But this court has essentially called that into question now.
I agree, and that's why we're hearing this case. But if you ask about what our case law is, and I'm interested if you've read there was a case out of the Kansas Supreme Court last year. What's your thoughts on that case, Gleason?
And Your Honor, that's the reason I provided the, albeit tardy, notice of additional authorities, because I figured that question might come up. At the founding of the Iowa Constitution, the closest case I could find was State versus Johnson. That is an marshalling instruction with an element that was omitted, and it was summarily reversed. So at least at that point, it seems that we did recognize structural error. I see my time is up.
Mr. Kenworthy.
May it please the court, counsel. I think I'll start where, on the jury instruction issue, I think Justice Christensen, you brought up an interesting point on how the jury instruction was written and then kind of the defendant's requested instruction. I guess here nobody requested, the defendant did not request the model instruction, and the court gave its reasoning for why it kind of altered the modeling instruction. But I think the interesting instructive part is the discussion by the parties at the jury instruction conference, because really the court is saying, I think we're basically saying the same thing, we're just writing it different ways. And the defendant kind of leaves it at that, saying he thought maybe there was a disconnect. And so
Made a record and objected and said, I want the words by deception in there. Isn't that correct?
his instruction, which would have had by deception in the first element.
Taking the court's instruction, adding the words by deception. That's the way I read the record.
I think he was asking for his instruction, and the court said, well, your instruction isn't correct either. You put intentionally in, and also the knowingly doesn't modify the acting of deception.
Separate issue. There was a separate argument about that, as I think Ms. Wilson pointed out. Okay.
And the court said, he re-asked, so are you not going to include by deception? And the court said, well, I think the court then offered to rewrite it a different way and then asked the state what they thought, and the state said they thought that was duplicative. And the court said, I think we're basically talking about the same thing. So again, I think the state agrees that the defendant preserved error on whether the jury instruction was correctly written under what he would have provided. But I don't think any constitutional arguments or anything else was argued at that point. Or again, going...
Is that in the trial court, I mean, this harmless error is a appellate doctrine. So we're, if there was an error, a preservation of error on the instruction, then we get up on appeal, which is where we are. And if we decide that there was an error in the instruction, then it's a review of appellate procedure, whether to apply harmless error and whether constitutionally we can, right?
The broader argument that's being made is there was an element missing from the jury instruction, thus depriving the defendant of a fair trial, is the argument he makes later, and then on appeal. And I think if he had brought that issue up, because I think in the jury instruction conference, really what you have, I think, is the judge and the state basically saying, we all agree causation has to be proven here. We just think this instruction meets that. And he's saying, I think there could be a disconnect. He doesn't point out how there could be a disconnect, like how could something else in the record confuse the jury under this instruction. He doesn't raise also that if he doesn't get this instruction, the state's lessening its burden, which is the argument is made on appeal, thus depriving him of a fair trial. And I think those constitutional issues need to be raised at that point, which is then the basis for asking the court now to depart from its precedent and from federal precedent to apply a different standard alone under the Iowa Constitution. I think some constitutional argument had to be raised there, and I think if it was, sorry.
The record seems to support the outcome of the case. But then Ms. Wilson today made me think of something that I hadn't thought of until I got here today. What if one juror, because I'll tell you what, there could be that one juror. What if one juror honestly believed the victim was going to pick this guy no matter what? for the reasons that he is qualified or he was in the right place at the right time, and she was going to take the first person who was willing to help her. What if it had nothing to do with his lies? Just one person. Wouldn't the instruction then be problematic?
I don't think so, because again, I think it has to go toward what, those are fact questions for the jury, what the state's arguing meets deception. And here, I don't think there was any argument that, hey, by him calling, it was always about the obtaining the money. And so again, I don't think the instruction can be read separately. I think obviously the acted kind of modifies back to the obtained. And again, this is all under the theft heading. And I think as the court instructed the jury, all these instructions must be read together. And that would include then instruction 17, which said, if you find theft, then you have to find the value of the property that was taken. And it gives the jury the amount. So I think reading all those together.
Argument, prosecutors spent quite a bit of time kind of saying, don't worry about the time. Don't worry about it. So that kind of is contrary to what you just said, that you think that the deception automatically goes with the obtaining the property. It seems kind of like the prosecutor took advantage of that separation of those elements and said, don't worry your pretty little head about that. All you got to show is they took something, and all you got to show is there was some deception.
Respectfully, Your Honor, I would disagree that the record, I think, that's referred in the brief, but I think if you look at the closing argument, that was in rebuttal talking about timing, and that was in response to the defendant's argument that the victim didn't feel deceived at these certain times until later. And then the prosecutor on rebuttal was saying, we don't have to prove when the victim felt deceived. The timing of when the victim felt deceived is not relevant. And then brought the case back to showing, we have to show when the defendant intended to obtain the money through his acts of deception. So,
By the prosecutor, it was the rebuttal portion of closing. On March 3rd, when he provided her with documents saying he was an employee of CSI and she signed those documents, that was his deception. That was fraudulent. Oh, excuse me, I went to the wrong part. Back up. There is nothing in there that says when or under what circumstances or what the timing of events that Ms. Wall had to believe that she was deceived. Are you saying it just only had to do with what he was doing? Doesn't matter at what point she found out about the deception?
deception requires when she feels deceived that they have to prove it. His intent of when he did it, the mens rea of having the state had to prove his knowledge of when he was deceiving her. And so I think...
You go ahead. Doesn't that untether from instruction 1 there, on or about March 3rd? I mean, if it could be any time that we're talking about.
Yeah, that's the one instruction. There are 2 instructions, so that have the different dates. But again, I think those go to when he obtained the money. I think the deceptions, and this goes to back to like the Hogreff case and how we talk about the history of the theft by deception statute kind of encompassing all fraud. So again, I think the state did argue that there were multiple acts that the defendant kind of committed then to obtain the money. I think the state specific language is multiple acts of deception to then obtain the defendant's money. And so I think reading those together, depending on what definition of deception was used then in the separate instruction, that the jury could find that this deception then led to him obtaining the money. I don't know that there had to be a singular act of deception, but that he acted with deception, so multiple acts of deception to obtain her money, I think would still satisfy that.
Consequences be if we were to hold in this case omitting a element from the marshalling instruction? Is a structural error automatic retrial? What effect would that have on other cases?
To one of the problems is, and I think the Supreme Court addressed, U.S. Supreme Court talked about this in Nader, when we say omit, I think Nader, as the court said there, that was a case, I think they even used the phrase, that came in a test tube, because you have both parties saying there was clearly an omission of an element here. So that wasn't that wasn't contested. But here, I don't think you have a missing element. To the best issue, I think it would be what maybe the court would call a misdescription, the possibility that maybe something was misdescribed. And when we get into that issue, then it kind of becomes what is a misdescription? You have to look to the facts of the case usually on marshalling instructions to see what are we actually looking at, what does that mean? And I think then you're still needing to look at the case and the facts and how it was written and then what the prejudice standard would be. And so I don't think there's really any reason the Supreme Court's, I think gave a reasonable argument why, given its case law, harmless error should still apply in constitutional issues around jury instructions. And I don't think that this court should depart from that precedent. And on that question, I think there's been some discussion. I don't really think our case law is confused, or not confusing, but unclear on this issue. I think it depends on how the phrasing of harmless error is being used. We have non-constitutional harmless error, and then we have the constitutional harmless error. And in Schuler, I think this kind of got a little confused because nobody raised a constitutional argument. The standard of review was for errors at law. And then the court kind of on its own jumped to Nader and said, you know, so the standard we might have to apply would be whether all the elements were met beyond a reasonable doubt, which isn't the standard for non-constitutional harmless error. But then again, still found we don't even need to get there because there was error, so we're going to send it back. And so, again, I think for the majority of the time, harmless error is useful in that in most of those cases, Schuler, Shorter, Cooley, the case did go back.
Your opponent mentioned State v. Johnson from the founding era. Are you familiar with that?
He cited, yes, I read that case.
Think about that.
I don't think that it applied structural error. I think the court didn't get to that question because I think it said if there was something else in the jury in the instructions that might have led us to that, maybe we could have found there was no prejudice, but it wasn't there, so they sent it back. And again, I think that's whether harmless error, I think we're talking, is it constitutional or non-constitutional, always gets a little confusing in anything pre-Chapman of the U.S. Supreme Court. And I think our court has always followed post-Chapman that if there's a constitutional error, we would apply harmless error. But again, I think there's, even under, so like the Nader dissent, I think has an interesting line. Justice Scalia says, he's not totally saying that you shouldn't apply harmless error. I think he calls it harmless error of a peculiar sort, to find that if the missing or omitted element is necessarily determined by the facts, the jury found it anyway, then you can still apply harmless error.
So applying harmless error in this case, assume that we believe that there was an omitted element here and that the causation instruction should have been given. Is the error harmless? I think the defendant would say that the representations or the deceptions that were made in terms of his employment at this company really weren't material, and that the things that were true is that he was a licensed bondsman, and maybe the evidence would show that she still would have tried to secure a bond through him. So maybe there is a fact question on whether these specific representations are the things that actually induced her to give him the money versus his employment status. Like maybe she didn't care what company he was affiliated with. What's your thought on that?
I still think under these facts, there was no unconnected deception that could be found. I think the jury, by its finding, would have read these instructions together, given the facts of the case. The defendant knowingly acted with deception. And again, I think in the way the case law reads theft by deception, it is given a broad reading of kind of our overall fraud statute. So his scheme of kind of committing or telling these acts of deception in order to get her money, I think would all fit still under related to his knowing deception to get her money. So I don't think I think the example the defendant uses in his motion for new trial was he could have told her his age was a lie and then he would have sold her his car.
Error, unless I'm wrong, isn't it the state's burden to prove that the error was harmless? And if there are at least fact disputes about which of these deceptions are the ones that induced her to actually part with the money, I mean, doesn't that require a new trial?
Well, if you found harmless error, if we apply the constitutional harmless error standard, yes, then prejudice is presumed and the state would have to prove that beyond a reasonable doubt, which I think we do here as we argue in our brief. I think they're...
Harmless error question. So in analyzing the question, there's sort of two facets. One is, you know, how close did the instruction come to being correct if it was incorrect? And, you know, can we look at other things like the fact that the trial information said theft by deception, and that was read to the jury, and I think that was also mentioned again in the jury instructions. Do we look at the combination of that and the factual record of, his, Mr. Thompson's conduct? Or, in other words, can we sort of combine and say, here's an instruction maybe that wasn't that far off, plus here's pretty powerful evidence of deception, that he wasn't just engaging in it coincidentally, he was engaging in it to try and get her money.
And I think our main argument would be there is not constitutional harmless error analysis that needs to even happen here, because the objection was to the way the jury instruction was written, so we'd have a non-constitutional application, and prejudice is only shown if the possible error was material. So again, here, I don't think you would look at the facts in the record and say, there's no possible fact that would really kind of take a juror to go, maybe he was deceptive because of, I don't know, some other unrelated bad acts that could have come in, and then I think those would raise a possible question. But here, I think the court can read the instructions. May I finish just over my time? Finish that issue, finish looking at how the jury instructions were written applied to the case. I think you have to look how those instructions actually rely to the facts of the case. And here, I think under that analysis, you find that if there was error, it was certainly harmless. And so for all those reasons, we'd ask this court to affirm. Thank you.
Wilson.
I just want to quickly respond to one of the points made toward the end. This is a constitutional error because the failure to have a jury finding on an element of the offense does implicate constitutional provisions.
Address whether or not this was the elimination of an element or just maybe a misstatement of the element. Does that make a difference, and is that the case here?
Make a difference. I believe it was an elimination of an element, but it does not make a difference because this court in Cooley and Coleman has said that the omission of an element is the same as a misstatement of an element.
I looked at your case, so I found one of my own. All right, I wanted to know if you saw this. State versus Geisenhaus from 1866, so 9 years after our Constitution was adopted. It is objected that this instruction was erroneous because it omits, with respect to the effect of a sale or keeping to sell, the words in violation of the provisions of the Act. Court goes on, there was no evidence or circumstances showing that the sales proved by the state were of the character allowed by the statute, but the evidence clearly established the contrary. Having regard to the evidence, the instruction was not erroneous, at least there was no error which could have prejudiced the defendant. So we applied harmless error to a missing element case 9 years after the enactment of our Constitution. So we take the Gleason approach. Isn't that a relevant precedent?
Having read that case myself, but based on your description, it would seem consistent with harmless error. Most of the cases I saw were where there was a missing element. The court looked to the other instructions to see if the element was presented, and then considered that a properly instructed jury. That's the vast majority of the cases from back then that I found. But yes, Johnson does suggest a different approach.
Doesn't discuss harmless error, does it? No. And there was a statute in effect at the time our Constitution was adopted that said something like, don't reverse for, technical errors or something. The court will, on appeal, shouldn't reverse for technical errors, something like that.
Statute throughout our history. I do quickly want to go back to the structural error argument. So the closest case probably to our constitutional right to a jury trial is Harrell versus State out of Mississippi. The Mississippi State Constitution also includes the phrase that the right to a jury trial shall remain inviolate. And there, they followed essentially Scalia's dissent in Nader, that it is always reversible error to deny an accused a right to a jury decision on all elements.
In Mississippi, that's been the law for, going way back. That's been the law before, I don't know, perhaps years decided. So that's different from us, where we have a precedent that goes the other way. Seiler would be the most recent case, right?
Potentially. Now, I will admit, even if you look at Seiler, there is a lot of discussion as to whether Nader is still viable. Justices have left the court, Thomas has switched his opinion, and even the Erlinger case cited by the state indicates the U.S. Supreme Court would reverse without consideration of harmless error if past crimes are not submitted to the jury for enhanced sentencing, for example. Now, one last thing I want to do very quickly is to encourage the court to look at the difference between People versus Merritt and Harrell versus State. They're both cases where multiple elements of robbery were omitted from the jury's consideration. And when I say multiple elements, in one of them, it was all of the elements, pretty much. And Merritt applied the Nader standard on the basis that the attorneys argued the elements and the evidence was overwhelming. But Harrell found it error because there was no such thing as a directed verdict for the state. And we asked this court to reverse the conviction in this matter.
Thank you. The case of State versus Thompson is hereby submitted. We'll have a brief pause while the next parties prepare for the case of Hunter versus City of Des Moines. I think everyone's ready. We are now here for the matter of Hunter versus City of Des Moines. This is how I understand that the argument will go. The city will have 15 minutes, then Hunter will have 15 minutes, and then because both are further review, the city will have 5 minutes for rebuttal, and then Hunter will have 5 minutes for rebuttal. Is that your understanding as well? Okay, thank you. Ms. Mackel, you may begin.
Good morning. May it please the court, counsel. On further review, the city is requesting that this court reverse the Court of Appeals and District Court rulings related to discrimination and find that the city did not discriminate against Matthew Hunter. The city otherwise asks that the remainder of the Court of Appeals decision remain undisturbed. And the question the city is asking this court to answer is whether a law enforcement officer who engages in egregious behavior is immune from termination or perhaps any discipline at all if he can tie those egregious actions to a disability. The city asserts that Matthew Hunter is not qualified for his position and cannot establish a prima facie case based on two elements, based on his unique symptoms of PTSD as well as his conduct and actions on June 6th, 2021. To be qualified for a position, it's familiar, everyone knows that one must be able to perform the essential functions of the job. That is not just a question of training and experience and education. It also means that that employee must be able to reach and meet the employer's reasonable expectations for that position. The city of Des Moines requires of police officers that they must work under highly stressful and emotional conditions. They have to be able to maintain control of their emotions. They have to maintain intense concentration and alertness to stressful situations. They have to follow rules and obey orders. They have to adapt to rapidly changing situations, and they have to be able to use handguns and shotguns. Now, Mr. Hunter's symptomology indicates that he is not qualified to perform those functions as well as many others. His doctor testified that Mr. Hunter's PTSD is unpredictable. It's nonlinear. Even innocuous exposure to firearms could trigger his PTSD. And when Matthew Hunter is triggered, there are times, his doctor said, that he may not be able to control his actions. From over 2 years of counseling records, his PTSD was triggered just by having a conversation about police work with a friend. His symptoms include crying spells, anxiety attacks, angry outbursts, flashbacks, involuntary, distorted, and intrusive thoughts, and struggling to determine which of his thoughts are real and which are distorted. His own expert, his Dr. Grove, conceded that the conditions of police work were fraught with triggers for his PTSD symptoms. And it is true that some people with PTSD can manage these kinds of debilitating symptoms, but after 2 years of counseling, Matthew Hunter couldn't. And perhaps most persuasive is the fact that Mr. Hunter himself indicated that he was not certain that he could perform the essential functions of the job.
Another job. What about a job where he wasn't a line officer? I mean, the Court of Appeals didn't reach that issue, said they didn't need to.
And this was pointed out in terms of, well, the Chief Wingert was questioned about, couldn't you stick him in a room and have him doing just administrative work? Couldn't you keep him away from the things that might trigger his PTSD? And Chief Wingert said he could. Of course, he has authority to do that, but that would essentially be creating a new position, because that would be removing the essential functions of the job and placing someone in a room and insulating them from the realities of what a police officer has to do. So we know that having to create a new position, which is what that would be, is not a reasonable accommodation.
Your argument on appeal, you're not arguing that the grounds for termination are justified as a matter of law, et cetera. You're really just arguing about the prima facie, is he qualified within the meaning of the disability law, right?
As one issue, yes, we are arguing that the prima facie issue is unable to be met based on the qualified individual prong. And that is, again, two-part. That's symptomology and that is the conduct. But we are also asking this court to get to the issue of whether or not the city actually discriminated against him once you get past the prima facie. So just to pick up about the prima facie case, we know then, based on the expectations we just talked about and the symptoms that Mr. Hunter goes through, that high stress, that mental and emotional control, those are those requirements, and they can't be met by someone who goes into an angry outburst if there's even discussion of police work, if there is seeing a weapon, which is something his doctor said could trigger him, or seeing a body after a suicide. And that is the issue that when Mr. Hunter says that he was perfectly qualified all the way up until June 5th, had no problems in the employment arena, that's not correct. A week before his arrest, he saw a suicide, and he is the supervising officer on that scene. He walks away from the scene. A junior officer sees that he's basically zoned out, checked out, enough that he has to go check on him. So he is not fully functioning as a police officer.
that all these things are happening before he was actually diagnosed with PTSD and had not actually had any counseling related to it, so that with accommodation he would have been qualified?
Well, I'm going to separate that out in two ways. He had counseling. Shortly after Joe Morgan's death, go ahead.
Diagnosed with PTSD at that point, or was something less than PTSD?
Diagnosed with acute stress disorder, which we learned was basically the short version of PTSD. It's the thing that comes out the first 30 days. If it stays longer, then it becomes PTSD. So there was a diagnosis. But let me get to the question that you asked. Does it matter if this incident happened, the June 5th incident happened?
Talking about the fact that a week before he was arrested, he had had this other incident. And so I'm saying at the time that he was arrested, he had not yet been diagnosed with PTSD. And you're saying that because of the PTSD, he's not qualified. So does it matter that at the point that he was arrested and those events happened, he had not actually been diagnosed with PTSD?
I think the case law typically bears that out because the either identification or the disclosure of PTSD usually doesn't happen until something bad happens first. So I don't think that matters. But then if we even shift to his conduct, there is this issue with Mr. Hunter's brief where they said that there is no such thing as disqualification by misconduct, but that's not correct. And the city had cited a 10th Circuit case that basically said an employer is not required to retain abusive employees because such employees cannot be defined as qualified, and that was based on misconduct.
Through the whole record, there was a full-blown trial, obviously. Is there anything in the record that was put in the record of circumstances under which other officers were terminated? Because I know that Mr. Hunter put in comparators of people who received discipline far less than termination. Was there any evidence of when the city terminates a police officer?
Offered, and it was entered into evidence, a number of examples of people that the city had terminated in the last 5 years. It included an officer who made an inappropriate gesture to a fellow employee, very intrusive, inappropriate gesture. A person who had, multiple times just used poor judgment. And so, yes, there is evidence in the record that the city has terminated people for things much less serious than Matthew Hunter. In terms of, go ahead.
Not terminated. Did any of those involve situations where an officer was kind of using the badge in a threatening way? I think there were some bar fights, maybe, or...
Of the comparators that Mr. Hunter offered. And that was a situation where an officer injected himself into an investigation being done by the Altoona Police Department because they were investigating his wife. And so he went over, kind of flashed his badge, said, "I want to see the video," and threw his power around, and he received a suspension for that. And so, and again, and to be fair, he was cited for basically injecting himself into an investigation. However, the county attorney dismissed those claims before they went to any kind of adjudication. And go ahead, sorry.
Or charged with a crime?
Cited for the injection. It was like a public authority or a public person asserting themselves, but that citation was dismissed before it was adjudicated. So as argued, this issue of being disqualified based on conduct, it is an issue that is present and recognized by the courts, as I just cited. And I kind of think about this as a hypothetical, if we had somebody who was going to be a new hire. And in that application, they said, by the way, I just got arrested for public intox, and here are the list of things that I did. would it be discrimination to say that that person is just not qualified for the job? Even if they said it was PTSD related, and at some point in the future, I'd like to start this job once I get some counseling, and I can't tell you when that is. The city asserts that that would not be discrimination, and it doesn't make a difference then if this happens when somebody's already employed. And so, we look again to the policy, the expectations of the city, and the misconduct to see not only if backward was Mr. Hunter not qualified, but is there a propensity? Is there going to be a problem in the future with that same kind of misconduct? And that policy is on and off duty. Employees shall not conduct themselves in a manner that casts doubt on their integrity, honesty, judgment, character. And we should also remember, Matthew Hunter was a sergeant. He was in a leadership position. And so he was required to project an image of professionalism. And so we know what he did. He abused his authority, slurs, threats, threats to kill people, threats to kill families, criminal conduct. And we also know there's a propensity based on the medical records. He's
Acts there you just mentioned, all of the events that were used as justification for his termination were from one incident. It may have been a lot of different things that he did. He used slurred people and other things, but they were all from one incident. Is that correct? So some of the other cases that have been mentioned as comparables, they might have been also one incident, but there just weren't as many events in that one incident. Is that correct? Did you?
District court's approach was sort of creating a rubric, right? So we take the officers A through G, and then we break down each and everything that Mr. Hunter did that night into small categories. And then kind of said, oh, well, there's an X there, and there's an X there, so these people are comparators because I can pick out one thing that there's a commonality about. And that's the problem with that approach, is it just doesn't meet the rigorous standard that's required to have a similarly situated comparator. So yes, one incident. Although I would state that, there were phases of this incident. It was one, but we're talking about, transfer between many different law enforcement agencies, and it continues. And so there are new victims, there are new individuals who are being harmed by that.
From the place, the incident, to the actual jail was longer than usual, right? And the guy's drunk. I think everybody admits, very drunk. And I think it also maybe smoked some pot or something. I can't remember what the record showed. But my point is, he's obviously intoxicated. So can't it be viewed as one big drunken episode?
Well, I would say yes to that in a couple of, I would say yes in a limited way. About the marijuana, Mr. Hunter left the party because he had enough wherewithal to know that he should not be at a party where there's marijuana.
Corrected that he did not consume the marijuana. Okay. Thank you for the correction.
Rationality. He knew he needed to leave there. And so, yes, drunk, but if you have enough peace of mind to leave that party and say, I want nothing to do with this, and then you go about committing additional crimes and policy violations, I think that gets to the point where these are not just a single incident, it's multiple decisions to violate the law. Thank you.
May it please the court, counsel. My name is David Albrecht of Iowa Employment Attorneys PLC, and along with Kellie Paschke of Skinner and Paschke, have the honor of representing Matt Hunter. Every year, more officers die from suicide than by in-the-line-of-duty deaths. And according to defendants' own training documents, 41% of first responders polled said they would consider suicide in certain circumstances, one of which being termination following a mental health diagnosis. This epidemic shows the breadth and the depth of the stigma against mental health problems within policing and why these verdicts are so important. Now, the issues on this appeal can be decided by 1 point and 2 words, and that's same decision. The jury in this case unanimously found that the city discriminated against Matthew Hunter because of his disability, and then separately found that the city did not prove it would have fired Matt absent his disability. The second finding affirmed the first.
read that instruction to mean, well, okay, he wouldn't have had the whole episode on June 5th and 6th, but for his disability.
Your Honor, when you say that instruction, do you mean the same decision?
'Cause I thought about that argument, and I thought, well, okay, if they would not have made the same decision if he hadn't been disabled, well, is the jury putting themselves in the mindset that Mr. Hunter wouldn't have acted out as he did on June 5th if he hadn't had the disability, which I think is actually not really disputed, right?
But to answer the initial question, no. So when the jury is asked to consider the same decision defense, it is the burden shifts to the employer here to prove that take disability out of the equation completely. We're looking solely at the misconduct. We're not considering the disability, any associated thoughts or stereotypes to it. We are looking solely at what the city's justification was. Everything the city just now stated, even though a lot of it wasn't actually in the termination records, would they have fired Matt anyway based on misconduct alone? And the jury said no, and they said no twice. And the case law says that when the jury is rejecting that same decision defense, we can assume that that means that the disability or other protected characteristic was the factor that changed the outcome in this case. And so when we talk about whether it's the sufficiency of the evidence, which the Court of Appeals agreed there was sufficient evidence for every single element in this case, or whether we're talking about the stereotypes instruction, which could have at best only related to the motivating factor standard, which was the first question answered by the jury, but could have had absolutely no application to the second on the same decision defense. That's why everything being raised today can be decided by those two decisions by the jury. Because when the Court of Appeals stated, they said, well, the jury might have still found that the city, they might have fired Matt anyway for his misconduct, but they didn't analyze how the same decision defense rendered any potential error harmless. They set out across 3 different pages that there was a whole lot of evidence supporting the same decision defense, whether it's the comparator evidence some of your honors spoke about, whether it's the fact that they engaged, the city engaged in other acts of disparaging manner toward officers that they believed were weak, including Joe Morgan, or whether it was another finding of pretext. But the Court of Appeals failed to take the secondary step to say, okay, even if we think there's an issue with the stereotypes instruction, that error is rendered harmless. And we believe, of course, that the instruction is not a misstatement on the front end. And even if it was, could have been phrased better, I think, as the prior case was discussing this morning, it's not a material misstatement when we consider it as a whole. The jury was directly instructed on what the motivating factor standard was. And the stereotypes instruction in Instruction 26 was an ancillary instruction. It was not part of a charge instruction or a marshalling instruction.
Ask you about the city's argument then. The same decision defense kind of goes to the end point of this process about the reasons for termination. I think they're also making a separate argument that on the front end, he wasn't qualified for the position because of this misconduct and the particular symptomology of his PTSD. So can you address that issue?
Those in tandem. First, the PTSD symptomology was mischaracterized here. If we look at our briefing, we actually cite what Dr. Grove stated. At the outset, there was nobody at trial who said, we fired Matt because we were afraid of his future symptomology of PTSD. Nobody said that. They might have believed he was weak because of it. I think that was the inference from Chief Wingert's testimony. But Dr. Grove directly testified, and I think this goes to what you were saying, Justice Oxley, that Matt, through treatment, has learned coping mechanisms in order to deal with his PTSD. I believe the VA's website says 6 out of 100 people will generally develop PTSD at some time in their life. And through treatment, most of those will not need future treatment and will be able to cope with any symptoms. And so when they talk about the particular symptomology, I'm not really sure what they're talking about, because Dr. Grove did provide some testimony about PTSD in general and how sometimes that can be unknown. But with Matt in particular, he talked about the coping mechanisms he's developed through treatment. I I think we can all agree if an employee went to their employer and said, I've just been diagnosed with cancer. If the employer was to say, well, down the road, you might need treatment, and that's going to make it hard for you to come to work, so I'm just going to fire you now, I think we can agree that that's not allowed. And that's essentially what they're arguing. And the cases that they cite where PTSD was a factor in the termination and it was justified, there were ongoing issues legitimately preventing that employee from doing the job. In one, for example, their doctor had said they can't even answer a phone, things like that. But all of them showed that the employer went through an interactive process to see if there was a way to accommodate them first. We didn't even get that here. To your second point, Justice McDonald, about the misconduct, I would first state that's a jury question. The jury heard everything that they're saying, and they rejected it. There was no specific qualified instruction. The portion where this would be the closest is in the marshalling instruction, where it states that Matthew Hunter had to prove that he could perform the essential functions of the job with or without accommodation. Chief Wingert did not testify that Matt couldn't do any portion of his job. He stated, and I quote, he agreed that Matt was qualified. The city didn't ask a single witness whether Matt was unqualified. The only time it came up was when I crossed Chief Wingert and I asked him whether or not Matthew Hunter was qualified, and he said yes. Matt had just been promoted to sergeant a couple months prior. The city now wants to say, well, because of this single incident of public intoxication in which he didn't hit anybody, he didn't beat anybody up, unlike a lot of the comparators that we cited to, and which has now been expunged from his record so that if he was a new applicant, it wouldn't be on his record.
Kind of the elephant in the room for us, because we're in public service too, is the fact that he was repeatedly used his status as a police officer to threaten different people with repercussions if they proceeded to enforce the law against him. And that's really troubling.
I would push back a little bit on the use of repeated. I think it was once or twice, but I admit he would say, hey, I'm a sergeant with the Des Moines Police Department. But what I would say to that, first and foremost, is this was an argument to the jury. The jury got to decide whether or not that was something that could be terminable. And when the city phrases this as sort of a prima facie case, I don't think it fits very well there. I think it fits more into this was our legitimate non-discriminatory reason section. This is when they say, we didn't fire him because of his disability. We fired him because he was arrested and because he said these things and because he threw his weight around. And they rejected that as the legitimate reason, and then they rejected it again when they made the same decision finding. And one of the things that you're talking about throwing his weight around as an officer was that comparator evidence. There was the officer who directly walked into Altoona and said, I'm a cop, I want access to that information. And when he was prevented from getting it, he directly accused the Altoona Police Department of doctoring evidence.
Then I'm going to go after your family.
I would actually, well, I think what the city's ignoring there is that Jailer Streeter testified, and he said, I didn't take anything that man said seriously. The first question Jailer Streeter was asked by the city was, tell me about your interaction with Matthew Hunter. And his response was, I don't remember anything about it. He said that Matt was not a threat. Matt was not scary. When he got Matt to the Marion County Jail, he took the transportation, the standard cuffs off Matt and said, if I had any concern about that man, of course I would not have done that. He also testified that, and it was in his written report, which I think the jury was also allowed to consider, Jailer Streeter did not write on his own accord. It was requested of him by the city 2 days after. It's the only reason he wrote it. He did not make a complaint of harassment. The arresting officer, Sergeant then Lieutenant Keller, stated if he had any belief that there was any legitimate threat that Matt made to anyone involved that night, he would have not hesitated to file it.
Ask you this. In response to Justice Mansfield's question, you said that it's a jury question to determine, right, whether or not his conduct was sufficiently egregious to justify termination. At what point would it not be? How badly can a police officer or a judge or any other public servant, how badly can they behave and still get to have a jury question about whether or not
I think that is a fact-specific question. I can't say here's the precise line as to where it becomes a jury question and where it doesn't. But what I would say is we actually had evidence of this case of officers who were not arrested for what I would say would be objectionably more egregious misconduct.
Does that create a situation where a police department, maybe they haven't been as stringent about protecting the public by policing the police, so to speak, right? And maybe in the past they have not been as strict, and now it's like, all right, this is the time we're going to be more strict. And are they sort of getting penalized because they make progress in a sense in terms of saying this is the time to take this more seriously?
The city was trying to argue, hey, we just now adopted a one-strike policy. Maybe that's a conversation piece, but that's not the facts in this case. They actually had the same structure in place throughout these comparators through Matt, including the officer who engaged in repeated use of force violations over a period of years, got into a screaming match with a superior, and then beat a handcuffed suspect, dropped him on his face while handcuffed so that his teeth broke, was found guilty and liable for civil battery, for which the city paid $800,000. For that incident, the officer was not disciplined at all. And for the officer that got in a drunken bar fight off duty, in his paperwork, it was written that alcohol may have been a factor and that alcohol was considered a mitigating factor in that instance. Where was the mitigating factor for Matt Hunter? It wasn't there, and instead his PTSD was considered an aggravating one. We are not asking this court to excuse misconduct. We're not saying that every cop that has a disability gets a pass. Yes.
On the accommodation issue?
Yes, Your Honor. And so on this point, the Court of Appeals essentially said that there was sufficient evidence underpinning the evidence, the elements of the accommodation claim, but the timing subverted its validity, basically because it came after the arrest. However, the jury found not that Matt was asking for leniency or an accommodation in lieu of being terminated. The jury found that the city fired Matt instead of accommodating him. And that's in a few pieces of the evidence. I would actually go back again to the same decision defense, because the jury found, after hearing the city's evidence, they wouldn't have fired Matt had the disability not been in play, and they could have accommodated him instead. And to the
Trial, what was his status in terms of his ability to return to work? And then what was the testimony about alternative jobs that he could do if it wasn't kind of frontline police work?
testified at trial that he believed he could fulfill the essential functions of the role of a police officer. And Dr. Grove also testified that he had developed those coping mechanisms. There was no testimony at trial that Matt was prohibited from becoming a cop again. And as it pertains to the evidence of the available positions, I would push back strongly on what the city stated. The Rumsey case that was cited, that I'm familiar with, was reversed in part because it said, if you want to talk about reassignment as a potential accommodation, you need to identify vacant, full-time roles that the person could have filled. Now, we had other accommodations in play that were in the instruction, such as time, treatment, etc. But Chief Wingert testified, acknowledged under oath, not that he could have created a position. His testimony was that there were several vacant sergeant level and below positions available and that were desk duty administrative only. This was not something that would need to be created. These jobs already existed, and he admitted, I could have placed Matt in that role. Time and time again, he was asked on the stand, you could have considered this? Yes, I could have. You could have placed him in those roles. I could have. You chose not to. I chose not to. And when asked about whether or not he engaged in any sort of interactive process, his repeated answer was no. And the jury was instructed, I see my time has expired, may I answer my question? The jury was instructed on a joint instruction that if they found that the city failed to engage in good faith in an interactive process, it was allowed to infer that had the city done so, an accommodation would have been found. And we know, again, from the testimony, we were sure to put evidence in based on the Rumsey case and subsequent cases that there were vacant positions available that were purely administrative, and the chief admitted, I could have placed him in those roles while he sought treatment. I didn't want to. Thank you.
Sorry. I thought he said he could have put him in those roles, but I thought there was also an issue about Mr. Hunter was going to need to be gone for some period of time, kind of an indefinite period of time for treatment, before being able to do that.
Not testimony that he would need to be off indefinitely. The problem was part of it didn't get that far. So Matt said, maybe I need some time, maybe I need some treatment, maybe there's another role. But it wasn't, hey, put me in another role, but I can't start for 9 months or something like that. I think that the jury was perfectly allowed to infer, based on all the evidence, that had he been immediately placed in a more administrative role, he could have continued on in his job continuously while receiving treatment. Thank you.
City?
Thank you. The same decision, I mean, the reason we are here is because of a JNOV. We said that the evidence did not support the jury verdict, and so that is what we're asking this court to determine. And the same decision defense is probably the best example of that, in that every single decision along the way to terminate Matthew Hunter occurred before he said the words or the term PTSD. There was an investigation that was launched. He was put on administrative leave. His captain recommended termination. The assistant chief of police recommended termination. Chief Wingert endorsed that recommendation for termination, and that's what triggered the pre-disciplinary process. So all of those things happened before anyone mentioned PTSD.
State of the evidence on, once it did get to Wingert for the final decision, how much discretion did he have to kind of reject the prior recommendations and do something different? And had he done that in the past?
He had absolute authority to reject that, and he did testify that he had chosen different discipline than had been recommended along the way. In this case, he had already made up his mind at that point. There is a pre-disciplinary process that is required, and what he learned from Mr. Hunter is, I have a diagnosis of PTSD. That is not a disability. That is not in itself a disability. That is an acknowledgement of a diagnosis. And then he said, I need maybe some time, and maybe I need to go to counseling so I can kind of get back to where I was. And so the Court of Appeals was correct in finding that, first of all, that implies that we're going to forgive misconduct, that we're going to have retroactive leniency for misconduct, and that is, by its nature, not reasonable. It's retroactive, it's not prospective, which is what accommodations are supposed to be. But in addition to that, even Mr.
Point, is there a difference between the failure to accommodate claim and the discrimination claim?
Well, they're intertwined, obviously, because if Mr. Hunter is unable to articulate a reasonable accommodation, then he also cannot establish the prima facie case of being a disabled or a qualified individual who can perform the job with or without an accommodation.
But if the accommodation, I get your point about the not allowing an accommodation to excuse prior conduct. But if it comes out, I have this PTSD, I need some time and some therapy, and that would make me qualified, those seem like two different things to me as far as the qualification part.
I must have misunderstood your question, Justice Oxley. The actual accommodation that he requested, if you can call it that, because that's pretty vague, and employers are not required to sort of decipher what that means. But there was no evidence in the record that there was some prohibition against Mr. Hunter getting counseling as a matter of course. And in terms of asking for time, I need some amount of time. That is also inherently not reasonable, because it is, an employer deserves the right to know when their employees are going to be around.
That's the point that I'm trying to, so that goes to your accommodation, to their accommodation claim, I think. Separate from that, from just the disability discrimination claim, you said that also makes him unqualified. But I think So can you address that point?
Because the qualified individual inquiry is, are they able to do the essential functions of the job with or without an accommodation? The only accommodation we have on the table is an unreasonable accommodation. So that goes to the issue that he would not be able to establish a prima facie case of being qualified. Is that, okay. I see my time is almost up. Thank you very much.
Thank you, Your Honor. The record reflected that as soon as Matt woke up and realized he was trying to figure out what was wrong with me, he was reporting to his department that there was something wrong with him. He wrote immediately that I've been struggling since Joe's death and I'm going to seek treatment. He talked about going through the EAP, the Employee Assistance Program. Everyone at the department knew from day one. And when we're talking about the guidance committee that the city mentioned, 2 of the 3 members are appointed by the chief, and they knew, based on the discriminatory atmosphere he had fostered, which a 30-year employee testified at trial, was laid at Chief Wingert's feet, that Matt was gone. The jury could also have inferred that that simply meant more than Chief Wingert engaged in discrimination. And to your point, Justice McDonald, Chief Wingert said, sometimes I listen to the guidance committee, but I really can do whatever I want. And the testimony was also that at that pre-disciplinary meeting, when Matt told the chief, I have finally been officially diagnosed, I've got this plan, he told the chief, I want to come back better. He read aloud a text message that he had received from a colleague that said, we need people like you at this department who have fallen and gotten back up. We cannot have another tragedy, and I hope that you can be a great example for the other officers. And Matt said, that's all I want to be. The chief told him, I'm going to take a new look at everything. You won't hear from me for at least a few weeks. And then he fired him 15 hours later. They talked about forgiving misconduct. The Des Moines Police Department forgives police misconduct all the time. This is the comparator evidence we placed in and they placed in. When they talked about the officers they did fire, all of them had previously received a bunch of different warnings. They had been put on last chance agreements. This was not a first-time offense. Matthew Hunter's personnel file was full of nothing but thank you notes from members of the community, people who were school resource officers saying we don't often need a cop, but when we do, we are glad to have somebody like Matt Hunter on our side.
Preserve air on any objection to the comparative evidence? Okay.
Said the words no objection every time a comparator was offered on the record, and then they
Before the district court had definitively decided whether or not they were going to come in.
after the court said, I think these are going to come in, but by saying on the record no objection, rather than saying we preserve our objection in the motion in limine or asking for a standing one, that's waived. And then by proactively putting on their own comparator evidence, I think they made a change in decision to say, well, we think we're better off putting these other folks in evidence as well.
Motion in limine so definitive that they didn't need to object.
Said, hey, I think that these are similar enough for them to come in, but the court repeatedly stated with all of the court's rulings that I'm open to having my mind changed, and the city didn't. They just said no objection. I offered Exhibit 24A through G, no objection, and there were further no objections throughout the testimony. I think it's also notable to talk about, when we talk about these other officers, how fast it occurred with Matthew Hunter. This was within a few weeks of this one incident. The discussion about the officer who accused the Altoona PD of doctoring evidence, there was a full investigation, and when asked why it took so long, the city said, well, we have a policy where we let the entire criminal proceeding go through and be concluded before we do our part. They did not do that here. They rushed to Judge Matt Hunter, and they rushed to fire him as soon as it was clear that they knew he had a mental health diagnosis.
Frame, I want to make sure I've got my understanding of the record correct. Was he promoted to sergeant about a month before the incident? Or
Promoted to sergeant, he had Joe's dad pinned it on him. And so that was another indication that Matt was fully able to do the essential functions of the job. His lieutenant had actually stated that he had been really killing it in the position. He'd been doing great. I don't know that there's a lot more I need to say on this point or these points, Your Honor. I would just say I talked at the beginning about the statistics surrounding mental health and the struggles within the police force. Verdicts like these are important to change that belief. Justice Oxley, you spoke at a CLE a couple months ago talking about the attorney oath, and you reminded us about that one of the things in there is to look at the pro bono publico, what's for the public good. And when I look at the status of affairs with mental health and policing, and I look at verdicts like these, it's going to take brave people like Matt and members of this jury to change that. And so we ask that this court reverse the Court of Appeals, affirm the district court and the jury verdict in its entirety because it was based on substantial evidence. Any possible error was remedied by the same decision defense, and because it is for the public good. Thank you.
The case of Hunter versus City of Des Moines is hereby submitted, and the court will recess for the morning.